On behalf of the National Archives and Records Administration, I welcome you to lecture number 12 of the Becoming America lecture series, titled The Judges and the Constitution. Do they really have the last word? As a quick note to our viewers, tonight's lecture will complete the second part of this three-part lecture series. We will be on a holiday hiatus until we begin part 3, the Bill of Rights and Guarantees of Liberty, on January 17, 2023. Introducing our lecturer tonight is Dr. Joellen Chatham, the director of the Center for Civics Education at Concordia University in Irvine. Please help me in welcoming her to the stage.
Thank you again, Rachel. As always, we express our deep appreciation to the Richard Nixon Library and Museum and the National Archives personnel here. Tonight with us, we have once again Dr. Volker Janssen, who is a professor of history and political science at California State University, Fullerton. Dr. Janssen received his bachelor's degree from the University of Hamburg, where he not only went to college, but was a political reporter, and then was a political reporter for a brief time in the United States, and earned his doctorate degree in history and economics at the University of California, San Diego. So please welcome again, Dr. Volker Janssen.
Thank you, Joellen, for the flattering introduction. And thank you for joining us on this occasion and for letting me respond to a question that is on the mind of a lot of Americans when they read the news and follow the developments in national politics. Do judges really have the last word? Whether it's women's reproductive rights, private citizens' access to arms, the extent and limit of free speech in the distorting channels of social media, the boundaries of the individual's freedom of and from religion, the future of labor unions, the protection of our electoral process from hidden financial powers, or the legal accountability of former presidents for alleged criminal conduct, our eyes are peeled on the United States Supreme Court. Especially in a time of deep political division, and that is such a time, and that this is such a time, maybe one of the few things we can agree on, and a Congress so narrowly split that decisive action is often difficult, if not impossible, the highest court in the land becomes the body and the place where we want to find political certainty and hints at our national future. At the same time, deep political partisanship has not left the bench untouched, and we regularly examine the 9 justices for their ideological bends and dismiss them, rightly or wrongly, as mere extensions of the political battle raging across the street in the halls of Congress. So, while we yearn for comforting clarity, consensus, and shared common sense in the court's decisions, we rarely enjoy such relief. And so we ask ourselves the question, do judges really have the last word, not just with the curiosity of a student of legal history, but with all the anxiety of our current political tensions? My answer to this question today won't bring much comfort to those looking to see their political visions vindicated or reaffirmed. But I do propose that an historical long view on the judge's last word, and this is a fancy way to say the power of the court, can put the current moment in perspective. In the long view, history is less volatile and mercurial. In the long view, history also means that, in the words of Ray Charles, change is going to come. If you are looking for a quick answer to the question, do judges really have the last word, you won't be pleased. It's yes and no, sometimes, and it depends. That is, of course, the short answer to virtually any historical question worth asking. This might strike you as odd. This might strike you as odd at first. After all, isn't there a clear constitutional order that makes the United States Supreme Court the final arbiter of all constitutional questions? Don't then the judges that sit on this high bench have the last word on what the Constitution means, how we interpret it, how it empowers, frames, and restrains state and federal lawmakers, American citizens, the president, and the executive branch? That's certainly what any graphic illustration of the division of power in your political science 101 class would say. So you may now be wondering, what is this man going to waste our time with for the next 30 minutes? Please bear with me, and you will see that there's more to this question than meets the eye. Do judges really have the last word? Well, initially, the framers of the Constitution were not at all clear on what role justices should play in the conversation. When Madison had finally succeeded at coaxing and cajoling delegations from every state but Rhode Island to Philadelphia in the spring and summer of 1787, the proceedings were preoccupied with the structure and balance of Congress, the shape of the executive, the issue of slavery, and what limits and restraints on democracy state and national elites could get away with. Once the delegates conceded that the Articles of Confederation had made any form of national policymaking impossible, and that state courts were hopelessly inadequate for impartial applications of any national laws or the resolution of interstate conflicts, and they conceded this by their very presence in Philadelphia that this was the case, a broad consensus existed that the nation needed a federal court. This court, some of them thought, could have the power to overturn state laws in violation of the Constitution, a fairly new concept known as judicial review. The framers knew of this new practice from the rogue state of Rhode Island, where state courts had threatened to invalidate the state legislature's tender law of 1786. That law required merchants to accept the state's hyperinflationary paper currency at full value or face heavy fines, a punitive measure Rhode Island judges found in violation of the state constitution. While the Rhode Island court did not prevail in its power struggle with the legislature, many framers who were reading about this in the newspapers in Philadelphia embraced the concept of judicial review. Nationalists and wealthy men, appalled at what they considered the excesses of democracy since the Revolution, finally saw a way at which a national government could halt some of the reckless debtor relief laws some states had passed to accommodate struggling farmers in the depth of the economic depression that plagued the nation in the 1780s. Others were not sure they wanted a panel of judges to have the last word on laws expressing popular will. John Mercer, a Maryland delegate who attended the Constitutional Convention only very briefly, quote, disapproved of the doctrine that the judges, as the expositors of the Constitution, should have authority to declare a law world. Instead, he argued, laws ought to be well and cautiously made and then uncontrollable. Rather than debate this point to the final conclusion, however, the convention focused instead on the much broader issue of how the national government could fend off constitutional violations by the states. Delegates imagined different variations of a federal veto power. Some proposed a committee consisting of members of Congress and of judges. Others advocated for a full congressional review of all state laws. In all cases, they thought that the last word on the constitutionality of state laws should rest with Congress. Luther Martin, a delegate from Maryland, eventually offered the solution the delegates could agree on. The Constitution, Martin proposed, should declare explicitly that the Constitution and the laws of the United States shall be the supreme law of the land, and the judges in every state shall be bound thereby, and thing in the Constitution or laws of any states to the contrary notwithstanding. This is Clause 2, Article 6, and henceforth became known as the Supremacy Clause. It remained the only procedural mechanism for enforcing federal supremacy. But this was not the same broad empowerment for courts to practice judicial review, for judges to have the last word. After all, its text only spoke of state judges invalidating state laws that violate the Constitution or other federal law. In short, the framers only made it possible for the Supreme Court to practice judicial review. What that would look like exactly was for others to determine. And so, for the first 14 years, the United States Supreme Court rarely got to have a word at all. A ruling in the case of Chisholm versus Georgia in 1793, under the first Chief Justice, John Jay, affirmed citizens of one state to sue another state, a decision that had no time to become precedent. Congress and the states had the last word there 2 years later. The 11th Amendment from 1795 clapped back at the Jay Court, refusing U.S. citizens the right to sue other states, or foreign individuals for that matter. The amendment process, the most formally constitutional remedy to any justice's last word, was in operation here. It only succeeded one other time in American history, however, when Congress and 2/3 of the states affirmed the federal government's authority to levy uniform taxes, federal income taxes. The 16th Amendment of 1913 specifically overruled the Supreme Court's decision from 1895 in the case of Pollock versus Farmers Loan and Trust Company. That year, Chief Justice Melvin Weston Fuller insisted that federal direct taxes had to be apportioned to the size of states. 18 years later, Congress had the last word and overruled it in the amendment. Let's return to the origins of the power of justices. John Jay was disappointed with the position of Chief Justice and left the post to serve as governor of New York instead. The next confirmed appointment, Oliver Rutledge and his associates, bid their time in Philadelphia's Independence Hall without being asked for their word in any legal dispute of significance. This changed when John Adams nominated his Secretary of State, John Marshall, as Chief Justice. Adams had offered the post that was relinquished by the ailing Rutledge to John Jay, but John Jay was so frustrated with the powerlessness of the court that he preferred to go to Westchester, New York, and become a farmer instead. So Marshall was nominated and confirmed during the lame duck session of Congress in January and February 1801. He then took command of the Supreme Court just in the nick of time. Not only had American voters denied Adams a second term and chosen his political opponent, Thomas Jefferson, to the presidency, the Federalists saw themselves trounced by the Democratic Republicans, the heirs to the anti-Federalist movement, in Congress as well. From the election of 1800 onwards, Federalist advocates of a strong and active national government remained in a minority and generally out of the White House until the Civil War. It was John Marshall who kept the Federalist light burning in the national government until his death in 1835, after 34 years as Chief Justice. During these 34 years, Marshall often seemed to have the last word, thanks to his ruling in the case of Marbury versus Madison in 1803. The most foundational case in American constitutional history cleverly established the Supreme Court's domain of judicial review, that gavel that would let justices have the last word ever since. The facts of the case were these. After John Adams and his federal majority in Congress had lost the national election in 1800, they passed a law that created new federal courts and added judges. The Senate very quickly approved about 16 new circuit judges and 42 new justices of the peace. Their commissions became valid as soon as they were delivered by the Secretary of State. But by March 4th, 1801, William Marbury and a few other appointments had not yet received their commission, and James Madison, the Secretary of State under the new Jefferson administration, refused to deliver them. At that time, a presidential term still began in early March rather than in January, the way we know it now. Marbury sought to compel Secretary of State Madison legally and petitioned the United States Supreme Court to issue a writ of mandamus, which is a legal court order to an inferior government office to execute its proper duties. At first glance, this would have been an easy opportunity for the Federalist Chief Justice John Marshall to stick it to the new Democratic Republican government and rule in the petitioner's favor. Marbury's very appointment, one of Adams' many midnight, i.e. last-minute appointments, was certainly in an attempt by the Adams administration to frustrate his successor with an enlarged and overwhelmingly Federalist judicial branch. But Marshall knew that the court did not yet enjoy the legitimacy and respect in American politics and government that would permit such muscle flexing. So, the Chief Justice asserted the court's power in a sly way that let Madison and the Jefferson administration win the battle, but have the Supreme Court win the war. In his opinion in Marbury versus Madison, John Marshall did agree with Marbury, the petitioner, that Madison had refused him his commission illegally. Here he pointed to the Federal Judiciary Act of 1789, which stated that the Supreme Court shall have exclusive, that means original jurisdiction, and also have appellate jurisdiction, and that it shall have the power to issue writs of mandamus. So Madison had violated federal law. But that was not Marshall's last word on the matter. He then declared this part of the Judiciary Act of 1789 in conflict with the Constitution. Why? Well, the Judiciary Act of 1789 implied that Marshall's Supreme Court could have original jurisdiction over writs of mandamus, that it could be the originator of an order to the government office to execute its duty. By contrast, though, Article 3, Section 2 of the Constitution stated that outside of a number of specific circumstances, the Supreme Court shall have appellate jurisdiction only. While this sounds like a simple procedural error on Marbury's part, he should have petitioned the lower federal court first, and then could the Supreme Court have considered the case on appeal later, Marshall's point was bigger than Marbury's measly justiceship. He found a federal law in conflict with the Constitution. By rejecting Marbury's petition and letting the Jefferson administration win the case, he established the power of the Supreme Court to interpret the Constitution and be the final arbiter of the law. It is emphatically the province and duty of the judicial department to say what the law is, he concluded in his opinion. The practice of judicial review by the Supreme Court of both state and federal laws had been established. In the 220 years since, it has been the most important legal precedent in the nation's constitutional history. So let's return to our question, do judges really have the last word? At this point, it would seem that this was certainly true for John Marshall. To be sure, Jefferson never made peace with the principle of judicial review, even as he was unable to topple it. The question whether the judges are invested with exclusive authority to decide on the constitutionality of a law has been heretofore a subject of consideration, Jefferson wrote a friend in 1815. Certainly, there is not a word in the Constitution which has given that power to them more than to the executive or legislative branches, he concluded. Jefferson's complaints were to no avail. Marshall's precedent prevailed, not least because of the justices' keen wit and argumentative skills. Jefferson dismissed Marshall, but he also feared his quick mind and rigorous logic. So great is his sophistry that you must never give an affirmative answer, or you will be forced to grant his conclusions, Jefferson told another judge. Why, if he were to ask me if it were daylight or not, I'd reply, "Sir, I don't know. I cannot tell." While the Jefferson administration shaped the nation's first decade in the 19th century, John Marshall's tenure as Chief Justice endured for more than another generation. At the time, the 4 or 5 associate justices and the Chief Justice tended to share quarters in Washington, D.C., an ambitious but profoundly underdeveloped and provincial shell of a city. Their sessions were held in a windowless back room of the Capitol building. None of the public attention and decorum surrounded their work that we know now. In this familial setting, the charming and clever Marshall generally succeeded in bringing his associate justices over to his position. The Marshall Court was truly John Marshall's court. So when you consider that he presided over 1,000 decisions, that he wrote over 500 opinions of himself, then it might be fair to conclude that John Marshall had the last word in the struggle with Thomas Jefferson, James Madison, and a series of other presidents. But of course, Marshall did not live forever. When he died, President Andrew Jackson replaced him with a loyal Southern crony, Roger Taney. During his tenure, the philosophy of states' rights that Marshall had spent his life stamping out in state and federal laws regained its relevance. Chief Justice Taney completely overthrew some of the precedents Marshall had established in a number of cases. But that did not mean, did that mean that Taney had the last word? Consider the case of Dred Scott versus Sanford of 1857, arguably the Supreme Court's lowest point. The enslaved Dred Scott sued his owner for freedom in a Missouri court on the grounds that he had been moved to the free Wisconsin territory for several years. Missouri law allowed any person to sue for wrongful enslavement and also rendered any person free once they were moved to a free territory. Chief Justice Taney wielded the power of judicial review wildly on this occasion, throwing out Missouri laws and dismissing the Missouri Compromise that Congress had agreed upon in 1820. Black people, Taney declared, quote, had no rights which the white man was bound to respect. And the federal government had no authority to limit slavery in its territories either. Taney's last word threatened the expansion of slavery, or rather promised, from the southern perspective, expansion of racial slavery to the north and west, and escalated sectional tensions so severely that it secured Republican victory in the elections of 1860. So Taney was hardly the last word on the matter. It was Abraham Lincoln's, whom, ironically enough, Taney was obliged to swear in 1861. So now we know how justices got to have a word and the difference that that made. But the story of Marshall raises the question, if Marshall's rulings prevailed so long only to find their challenges over time, does the judge's last word belong to the person or to the set of ideas they propagate? In other words, is it judicial doctrine that prevails rather than individual justices? This question makes all the more sense to ask when you consider the fact that only a handful of justices ever enjoyed the dominance of a John Marshall. Maybe it's best to consider the judges as part of an intellectual, even ideological moment or movement. The influence of justices is not necessarily just measured in the number of majority opinions they get to issue, but in the way they shape overall jurisprudence. In the course of the court's history, certain judicial philosophies prevailed over others. There was, as you already know, federalism, an era of legal formalism, the legal realism of Oliver Wendell Holmes, who in his time urged his brethren to not shut their eyes to the practical effects of the law, a commitment to judicial restraint, on another occasion mandating minimum interference in congressional and executive power, and then there was also textualism or originalism of Antonin Scalia and today's conservative justices on the Supreme Court and the lower courts as well. The historical research of original intent, which textualism promotes, was an odd errand 40 years ago, but now accompanies the majority of cases. By that measure, one might say that Justice Antonin Scalia had the last word years after he drew his last breath. In 2016, when his successors overturned a woman's right to an abortion in Roe v. Wade from 1973 with their ruling in Dobbs versus Jackson Women's Health Organization in June 2022. If judicial philosophies strike us as too amorph, malleable, and imprecise to imbue them with such agency as to enjoy a last word, and I think they do strike me as too amorph for that, then maybe it's the presidents who nominate the justices that enjoy the last word. In today's political climate, we certainly talk about nominations to the United States Supreme Court as if they were presidential accomplishments, not constitutional duties. In 2016, when the Republican-controlled Senate refused to act on President Obama's nomination of Merrick Garland to fill Scalia's seat with the argument that it was 8 months before the election, Democrats understood this as the derailment of Obama's final accomplishment, shaping the bench. And Republicans cheered the confirmation of Amy Coney Barrett on October 26, 2020, 1 week before Election Day, as one of the impeached president's major accomplishments. But it's difficult to predict whether and to what extent justices do their nominators' bidding. Consider Chief Justice Earl Warren, nominated in 1953 by fellow Republican and President Dwight D. Eisenhower. Warren had been prosecutor, attorney general, and elected governor of California for 3 consecutive terms. He was one of the stars of the Republican Party. When Eisenhower nominated him to replace the deceased Fred Vinson, he hoped for a force of stability and continuity, not a legal revolution. Yet, in its very first session, the Warren Court surprised the nation and the president with its unanimous ruling against school segregation in the case of Brown versus Board of Education of Topeka, Kansas in 1954. To this day, and hopefully for good, Warren's last word was that the doctrine of separate but equal has no place in American education. Later rulings of the Warren Court would expand the rights of the poor, people of color, establish legal protections for the accused in state courts, and establish the one-man, one-vote rule. Not what Eisenhower, a Kansan comfortable with segregation, had in mind. We don't know exactly what the president responded when he was asked what his biggest mistake had been during his presidency, but allegedly he said something to the effect that this dumb son of a bitch, Al Warren, was in fact his biggest error. Or take Harry Blackmun, a justice appointed by Richard Nixon, who sought to redirect the Supreme Court under Earl Warren's successor, Warren Burger, into a more conservative direction. Nixon's previous attempts to fill that court vacancy with the South Carolina segregationist Clement Haynesworth and the Floridian Harold Carswell with white supremacist sympathies had failed in the Senate. Instead of becoming a voice of social conservatism and states' rights, Harry Blackmun instead achieved national recognition for his opinion in Roe v. Wade, the case we had already visited. When first assigned with drafting the opinion, Blackmun expected to deny the existence of a woman's right to choose. He then found himself talking to his wife and daughters. It was that conversation that changed his mind and led him to articulate the specific protection for women's right to an abortion that existed until earlier this year. Richard Nixon certainly did not have the last word here. The women in Blackmun's family had greater sway over the justice than the president. In the end, of course, Blackmun's word on the right to abortion did not remain the last either. It only endured until Samuel Alito's opinion in the Dobbs case this summer. Finally, let's check whether the appointments of Donald Trump proved loyal extensions of his will. Even here, we find that Supreme Court nominees demonstrate little deference to their nominators. Across the nation, Trump-appointed judges dismissed the president's evidence-free claims of election fraud and just recently rejected an emergency request from the beleaguered former president to intervene in the dispute over the classified documents he had collected at Mar-a-Lago. The reason for this is simple, of course. Justices enjoy lifetime tenure, and the Constitution contains only the vaguest descriptions of conditions under which they can be impeached. A political process as rare in American politics as it is unsuccessful. Whatever gratitude a nominee might feel at the moment of nomination, the stability and prestige of the justiceship erases political obligations, if not necessarily political leanings and preferences. Trump's justices may be as fond of Republican governments as Obama's nominations have been of Democratic policies, but this rarely translates into direct quid pro quo. Back to our question then, do judges really have the last word? At this point, it looks like those justices who establish enduring precedent in their rulings are the ones who can claim to have that last word. But there have been many times in the court's history where judges lost the argument and did not get the last word, but still enjoyed the last laugh, metaphorically speaking. Take Benjamin Curtis, for instance, who strenuously objected to Roger Taney's unconscionable ruling in Dred Scott versus Sanford in 1857. His dissent was vindicated in the 14th Amendment, which established birthright citizenship and delivered a hopeful final retort to the contentious Chief Justice's claim that black people, quote, had no rights which the white man was bound to respect. Or consider John Marshall Harlan of Kentucky, among the longest-serving justices in the nation's history. When the Supreme Court under Chief Justice Melvin Fuller sanctioned legal segregation and public transportation in New Orleans in 1896, in the case of Plessy versus Ferguson, Harlan dissented. The judgment this day rendered will in time prove to be quite as pernicious as the decision made by this tribunal in the Dred Scott case, Harlan wrote. Largely forgotten for much of the 20th century, historians came to appreciate the vision and discernment of Harlan at that time, when the court routinely stripped the constitutional amendments of the Reconstruction era of their power to secure civil rights. He earned the nickname the Great Dissenter, but in the end, he probably had the last laugh when the Warren Court sided with his view in Brown versus Board of Education in 1954, the case that specifically overruled Plessy. Another famous dissenter on the Supreme Court bench, Louis Brandeis, formulated opinions on the importance of civil liberties many years before he even reached the bench. At a time when the majority of the court had little interest in the constitutional right to free speech, Brandeis joined his fellow Justice Oliver Wendell Holmes in a separate opinion in the case of Whitney versus California in 1927, a case involving the conviction of a woman under the state's Criminal Syndicalism Act. Those who won our independence, Brandeis wrote, believed that freedom to think as you will and to speak as you think are means indispensable to the discovery and spread of political truth. It mattered little then that later courts referenced this aside more often than the majority ruling. But in the future, Brandeis remained the one with the last word, the last laugh. So let's look at our question again. Do judges really have the last word? Now we know when and why judges got a word at all, that some of them believed they enjoyed the last word only to be proven wrong, that some had the last word until another justice took it from them, and that some only enjoyed a last laugh long after. We should also note here that the Supreme Court can only have a word in those cases that come before it. Judges can have the last word, but never the first. On the upside, they can pick their arguments. Thousands of cases get petitioned to the nation's highest court, but only a fraction make it on the docket. The judges can choose their words carefully. What, though, does that last word really mean? Clearly, this is about more than a political argument. It's about power. And what power do the justices of the Supreme Court have? Here, the answer is relatively simple. As much or as little power as Congress and the executive branch are willing to concede. The heft of judges' last words rests in the legitimacy of their institution, the court. Think of what would happen if the Supreme Court issued a ruling and Congress and the President chose to ignore it. If a state were to ignore such a ruling and would face no consequences either through the executive or the legislative branch. Judges may have the last word once in a while, but they rely on others to execute them. The first case that made this very apparent to the national public was Worcester versus Georgia. In 1830, the missionary Samuel Worcester, along with 11 other missionaries, had traveled the Cherokee Territory. The state of Georgia, however, required white men traveling in Indian Territory to carry a state-issued license. On those grounds, Georgia convicted the missionary. Worcester fought back and, with the support of the Cherokee Nation, brought his case to the Supreme Court, where they argued that the state of Georgia had no jurisdiction over the land of the Cherokee Nation. Chief Justice John Marshall agreed, stating that the relationship between the United States and the Cherokee Nation was akin to that of separate foreign nations, in which the state of Georgia could not meddle. President Andrew Jackson reportedly responded, "John Marshall has made his decision, now let him enforce it." His words have been probably different, but in either case, Jackson had no intention to do anything about the Supreme Court's ruling. Now, since the court had not demanded action by any party, no constitutional crisis emerged from Jackson's unwillingness to intercede. Nonetheless, the case raised the question, if judges have the last word and no one listens, do they still have power? Thank you.